I note your appearance as of last week. I
Yes.
believe it was October 11th.
Yes.
And you indicated you are co-counsel, and I just want clarification on that. Who are you co-counsel with? Because I note Dexter Kayama also.
Yes, and so Dexter and I are co-counsel representing Kahea.
Are you co-counsel with Mr. Wardeman or not?
That was, we had left that in when we submitted our filing. Mr. Wardeman wasn't, he was off island at the time, so we had that in there, but I recognize that that may have caused some issue with the other parties in this case as they raised it in their very lengthy submission. And so we're co-counsel, Dexter and I, for
Okay.
Kahea.
Okay, and so Mr. Wardeman did a notice of withdrawal.
Yes, and his withdrawal was as to both the Kahea, the nonprofit entity, and all of the individual
Yes.
parties.
Ms. Pichota, it was quite a surprise to me to wake up Tuesday morning and find that the notice of withdrawal of Mr. Wardeman had been submitted the day before.
Yes.
And I have to ask you whether or not you knew this was going to happen and when you knew.
I think that we just want to leave the record as it is, and we have to come forward now. That's all. I've written my motions and explained what I'm able and willing to explain. So, just for clarification, Mauna Kea and Nainoho and the other petitioners, they're not all Mauna Kea and Nainoho. It's just become kind of a habit that we say that because of the Supreme Court case hearing being called Mauna Kea and Nainoho et al. When we were in the previous contested case hearing, we were individuals, and the reason is because we have individual rights.
I don't mean to
Pry or
belabor the issue, but I do need to inquire.
Yes.
Because it's pretty serious that on the pretty much the eve of the contested case hearing that your lawyer withdrew. And
Yes.
so I appreciate that you would prefer the record to stand as it is. I heard you say that. My question to you is, are you fully prepared to go forward with no prejudice to yourself?
It's, in my opinion, Your Honor, it's prejudice to everyone, kind of either way. We were, and let me just explain, we were forced to have to put all of our stuff in very quickly.
When you say that, you're talking about after he withdrew.
No, while we were, well, I don't even know when the sequence was, but we were basically just trying to get all of our pre-hearing statements and all of our exhibits and witnesses identified and all of their information in. And I think we've made a few mistakes, but essentially we got it in.
Yes.
I would like to say, and therefore we are ready as we can be at this time, but at the same time, you know, people are asking for a continuance, and everyone's got to ask for what they need.
And may I ask you also whether, when you knew that you would not be that you would be without counsel?
Mm-hmm. I knew that I would be without counsel the day before the letter came out, and I acknowledged that.
Okay. And are you able and willing to go forward on your own?
Yes, I am.
All right.
Judge Amano, we did the last hearing pro se, so we are aware of what that entails.
Are you prepared to go forward without a lawyer? You've had a lawyer all this time. I think we saw you here just once before.
Yeah, we had an attorney because we had the case was accelerated to the Supreme Court. I'm glad Mr. Wardeman came with us when we were remanded because of the lack of due process. So if anything I'm a little bit leery about is without his oversight that due process will not be as good as we expected it to be this time around. But I'm prepared to do what I need to do.
Okay, and you don't have any objections or anything else to say about Mr. Werdeman's departure?
No, I wish him well. I mean, he's a wonderful guy. Did a great job, great service. And that privilege between me and him will remain between me and him.
All right, Mr.
Thank you
Nenes.
very much.
Clarence Kuching.
Good morning, Mr. Ching. When did you learn that you were not going to have a lawyer?
First of all, let me object to your question because I think that question may violate attorney-client privilege. But since you asked, and I'm not trying to hide anything, it was suggested. I don't believe I knew that Mr. Werdeman was going to withdraw when he withdrew. I believe I got a hint or a suggestion that he was going to before he did. And it was the day before.
Mr. Ching, I'm not asking the question to be nearly or curious.
There's quite a bit of controversy on, why Mr. Werdeman withdrew. And the accusations that seem to be most prevalent don't quite state that when you made your suggestions of the month of October, that it was not a time certain. There were no dates certain. And therefore, from my standpoint, and by the way, I am a graduate of law school. I don't think that Mr. Werdeman was obligated to block out the whole month of October because your dates were not certain. And so all of these rumors and accusations, I believe, are unfounded.
On October the 3rd, when we met, it was very clear that we were going to go to hearing tomorrow, October 18th. And it was also clear that we intended to go to hearing sooner than that, but Mr. Werdeman said he had a one-week mainland
understand.
trip, so we pushed that back.
I understand.
And then the following week, there's a withdrawal. So
I really wasn't trying to criticize you and your actions.
no, and I'm not taking
No.
it that way, but I was about to ask you whether or not you had a chance to read the university's response to all of this. It was submitted
What I
last
just
week.
said could be said to be in response to their declarations.
So I was going to add that one of the things that they highlighted, and thus the nature of my question, is that all of us lawyers, and you know too, have ethical obligations to clients. And that's really the question or the issue at the moment.
Even though I was surprised by things that have happened, I'm willing to go forward as we are. No problem.
Thank you, Mr. Ching.
Thank you.
Mr. Flores, may I ask you also, when you learned that you would not have a lawyer to represent you in this case?
I'm not sure the exact date, but he had our full consent to withdraw as our attorney.
So you did consult with him and you consented to his withdrawal?
We consented that in his withdrawal and that we would continue pro se.
And today, as you sit here and participate in this pre-hearing conference, are you comfortable going forward and representing yourself?
Yes, Your Honor.
I appreciate the judge's requesting the clarification on the consent issue, because that was an issue. Seeing a notice of withdrawal being submitted out of the cold like that on the eve of a hearing, an evidentiary hearing, again, it's one of those things you always sort of have nightmares about, right? And there's always a question of whether or not there's prejudice, whether or not the proceeding can go forward. So the university appreciates the hearing officer's request for that clarification, that it appears that all 6 of Mr. Werdeman's clients did consent, and none of them feel that they've been prejudiced by his withdrawal. Again, there was nothing in his notice of withdrawal when he submitted it that either discussed withdrawal or consent, or whether or not there was going to be an issue of prejudice. So again, we appreciate that.